Hello and welcome everyone to ARPA-E University. We're pleased to start today's presentation, and just so those of you who are new to ARPA-E University, let me give you some background. ARPA-E University is a series of webinars designed to assist the energy technology community in advancing innovations that can dramatically improve how we generate, store, and use energy. Originally, ARPA-E University was focused exclusively on technology to market topics like cost modeling, finance, and business models. Now we're looking to build upon that foundation and expand ARPA-E University to include technical webinars and office hours. Just last week, we hosted the first ARPA-E University office hours session, which was a 30-minute live Q&A with an ARPA-E program director. In the months ahead, please look for these new types of ARPA-E University sessions, and we look forward to your feedback. Today's edition is an ARPA-E University focused on a technology to market topic, which is licensing. This session builds upon an energy innovation and IP strategy session of ARPA-E University that was held in December 2012, and a recording of that webinar is available on our website. Likewise, a recording of today's webinar and a copy of the slides will be available within a week on the ARPA-E website. Now I'd like to introduce today's speaker, Dr. Karina Edmonds. Dr. Edmonds has over 15 years of experience working with the private sector, universities, and national laboratories across the country in the innovation space. She's DOE's first full-time technology transfer coordinator and previously served as the director of technology transfer for JPL. She's a registered patent agent at USPTO and earned her bachelor's in mechanical engineering from the University of Rhode Island and master's and PhD in aeronautics from the California Institute of Technology. Karina, thank you for joining us today.
Thank you, Adam, and thank you for everyone out there joining us today. I'm very excited to have an opportunity to speak with you all, especially as I end my tenure here at the Department of Energy. Just to give you, I'll go to the first slide, just to give you an overview of the topics that I'll be discussing today. They include the types of intellectual property, a little bit on American Invents Act, just a little background touch upon BIDO, and then we'll move right into the topic of interest today, which will be licensing and licensing agreements. Also, I should mention that I'd like to leave some, ample time at the end of the presentation to field your questions and answer those for you. Then I'll move on to the process of licensing, give you examples of some typical monetary terms and time to execution, and then focus on the needs of startups and small businesses, who I expect are the larger majority of my audience today, and then the type of support that you can expect from your tech transfer office, and then how do you overcome barriers should you face those. So with that, we'll move right in. I'll skip over that first slide, as Adam has done a great job introducing me. And also, I'm not going to go down the list of all the different types of intellectual property, because I saw that Mr. Michael Ward, who presented previously, gave an excellent presentation on all the different types of intellectual property. But I thought it would be important to at least note the difference between trade secrets and patents, as this is a topic that is of interest to individual inventors and smaller companies, because of the cost savings that you may achieve using a trade secret versus a patent. And so, again, just wanted to highlight some of these. As you all know, that trade secrets can be used in business and give an opportunity to obtain economic advantage over a competitor who may not know or use it. It's important to know that so a couple of advantages of trade secret. Obviously, you would use a trade secret in the case where your trade secret would not be easily discovered, cannot be reverse engineered. Also, if the invention is not patentable. Some of the advantages are that the term is unlimited so long as you keep that secret, and that there is no registration fee for these trade secrets. The difference here with a patent is that you do obviously pay for patent costs, and you would want to use that in the case where your product could be reverse engineered, and that there is a 20-year term from the time of filing for a patent. So And obviously with patent protection, that eliminates the need for you to try to maintain secrecy, which could be difficult. And depending on business consideration and, you would want to weigh in terms of which way to go. The next slide, I will be just talking about some of the differences here that have recently been enacted with the American Invents Act, and that, for those that don't know, we have now gone to a first-to-file system. In the past, the U.S. was one of maybe two countries in the world who had first to invent. So if you could show that you were the first inventor, you had a shot at arguing for the patent. But now we've moved to a first-to-file system. And some of the differences are with the grace period. There's a lot of concern that the new grace period could hurt inventors in the case where, so the grace period is typically a 1-year time period that you have between a public disclosure and filing for a patent application. And with this new grace period, folks are concerned because if you presented your invention and somebody, and you are not filing for a provisional, and within that 1-year period, somebody else derives your invention independently, you could be barred from obtaining a patent. So your disclosure does not count against you as prior art, but somebody else's may. And so to be safe, I would really recommend at this time that you would file at least a provisional patent, which a few years ago was about $100 to $150 to file. I don't imagine it's much more than that, and at least you have your filing date saved. Some advantages of American Invents Act are this new microentity status, and I have a slide that describes the qualifications for that, and I'll let you decide whether you qualify or not. But if you do, you have a significant cost saving of 75% on most patent fees that qualify. And the other change is a third-party prior art submission. So in the past, you pretty much had to wait till the patent was issued to start the process of showing, prior art as an individual or independent inventor. And in this case, during the patent filing, you have an opportunity to submit prior art against a competitor's patent filing. So that's where that comes in. So let's see. The next slide just shows those filing fees that you're saving. So the bottom line is here you're effectively paying 25% of these fees, which is quite a savings. So I won't go through that. And then again, this slide just talks about how do you qualify as a microentity, and I won't go through all the different qualifications as it's going to be individual. And I should also mention that to support single individual inventors and small companies, the U.S. Patent Office is opening up satellite locations across the country that will be offering free technical assistance and even some assistance in writing your patents. And I don't have the list of those, but hopefully we can list those, and they may already be listed on the ARPA-E website. But that's definitely something that would be useful to you to have. What is the closest satellite office that can help you answer questions, because there are a lot of changes that will be taking place. Okay, so again, we're going to skip over microentity. Just a little background again, not knowing the makeup of the audience, it's important to know what enabled the whole field of technology transfer, and that would be the Bayh-Dole legislation in the early 1980s, which in a nutshell says that universities and nonprofits can retain title to federally funded technologies. And there are some exceptions, and there are some reporting and compliance requirements that I would definitely like to bring to your attention, because universities and larger entities usually have a compliance person or a whole compliance department, which is not typically the case with smaller companies. And this is very important, because if you do not report these inventions and comply, you run the risk of losing out on those inventions, and it has happened in the past. And we see that at the Department of Energy as well. Like I said, I mentioned with that. And universities do have a responsibility of commercializing and having some due diligence. In exchange, the government does get a royalty-free paid-up license to any inventions that are developed under their funding. And the Bayh-Dole legislation also requires that universities and nonprofits share royalties with the inventors. And the legislation requires a minimum of 15%. Most universities and nonprofits typically provide 25 to 30%, and within the DOE, I've seen anywhere from 15 to 50%. So, and again, and the revenues, the other part of that revenue needs to go back for research and education purposes as well. Another caveat is that these patents cannot be assigned except to a patent management organization. In that case, they don't need permission. If they're going to assign it to a company, that the university or nonprofit can request permission from the funding agency to assign. It doesn't happen that often, and in my 3 years here at DOE, I've seen maybe 2 assignments. And the reason it's not needed because just providing a company an exclusive license for the life of the patent is effectively an assignment. So it's in my 15 years of licensing, I never had an issue because companies understand the requirement, and they also are happy with an exclusive license for the life of the patent. So not an issue, but something that you should know. So if you ask a university or this nonprofit that you like a patent assignment and they provide some pushback, you know why. And they typically will let you know that's part of the legislation. Okay, so getting to the bulk of the presentation here, what is a license? And, just like, and again, this is covered, but it's also important to know a patent. Some people believe a patent is the right to practice an invention, and it's actually not. A patent gives you the right to exclude others, which is a very important right. And so with a license, which is an enforceable contract, the licensor waives its right to exclude the licensee to make, use, sell that patented invention in exchange for consideration. So the license can take on many forms, and we'll discuss in the upcoming slides, but it can be exclusive, it could be non-exclusive, it could be partially exclusive, limited either by time or field, or it could be limited to 2 or 3 licensees. So there's a number of ways to provide wide deployment for that technology. Let's see, and also that the patent or the invention that has not been granted can be a patent. I'm sorry. So this license that you're creating can be for patent. It could be for software, copyright, know-how, or a combination of those. And it's important to know that you are able to license before the patent is issued. As soon as you file for patent protection, you're able to license that invention. Okay? So the next slide starts to talk about the process for obtaining a license. And again, here I am assuming that you now have a patent that has been filed, some copyright, trademark. Even we're not, again, talking about trademark, but that could be a license to a trademark as well. The first step in any licensing for any licensing would be to identify the intellectual property that you are interested in obtaining. And it's also important to know that it's typically not just one patent. It will be a family of patents. And if you're lucky, they're all at the same institution. But most often, they may not be, and so you'd have to obtain a license from multiple universities or multiple entities, a university in a small company or a university in a lab. And that is increasingly the case where you have collaboration from multiple institutions. You will be required to provide a business plan, typically with some kind of market projection for that technology or the market that you are planning to pursue. They will verify the company or the individual has the resources to commercialize, and so including the business team is important. Let's see. And it doesn't necessarily have to be a company, so often individual can get a license, but sometimes the university or that nonprofit entity may require that you incorporate before negotiating a license, but it's definitely not necessary. At that point, once you've presented your business plan, actually the first step is once you identify the technology, that intellectual property, the university or, again, a licensor will let you know if that intellectual property is indeed available for licensing, and also what fields of use are available for licensing. So I should have mentioned that's probably typically the next step. Once you identify the next step, assume that that intellectual property is available for licensing on the terms that you need. So again, once you've provided a commercialization plan, and again, often the university or entity, and again, I keep saying university because that's my background or lab, but the licensor, which is the person that owns the intellectual property or is the legal holder, the patent, the assignee of that patent, that's who I'm referring to. It's a licensor, and that can be a university, a national lab, a nonprofit, or an individual. You could have somebody, and this has happened, where you have an individual who has written a patent, or they have gotten it assigned through their lab. Most federal agencies have a provision to allow the inventor to own the technology. If the university nonprofit declines, then it typically goes back to the federal agency. And if the federal agency declines to file for patent, the inventor has the option to and I know of several cases where that has happened, and the individual inventor holds rights to their technology. So it's important to note that this licensing process could be occurring with an individual inventor as well. So again, you will be asked to show either who your business team is, who are you working with, or how do you expect to raise the funds to commercialize this technology. There's typically some licensing fee or option fee that is required of you, and that is negotiable, and that is something that we're working on, and most universities and national labs are working towards reducing those fees for newly created companies and individuals. So the license will typically also have some milestones. And here again, we're talking about license, but often there's a precursor to a license, which is called an option, and an option is similar to a license because it gives the optionee the right to that technology if they meet the terms of the option. And a lot of times that term would be raising a certain amount of cash, which would enable you to commercialize. So once you obtain that license or again an option, you will be working towards meeting some type of milestone or payment, and after that, and it's also important to know that as I discuss these steps, this is not a single transaction or a simple single interaction. This is typically an ongoing discussion and process of going back and forth here with that licensor. Okay. So what would a typical license look like? It has a preamble, which discusses and outlines who the parties are to the license. It has definitions of all the different terms. And then it has a number of articles. And I should mention, again, we'll have this available. DOE, we recently put out a licensing guide for DOE labs, which would be useful probably in giving you an insight into other national labs as well, at least those that are government-owned, contractor-operated. And in there, it talks about what all the what all the definitions are. The definitions, again, discuss what an effective date is, what the field of use is, if there's a licensed product, the licensing process, what net sales mean, what patent costs are, what the royalties will be. And then that defines it. And then there's a grant clause, which is usually the most important part of the license, which specifies what rights are transferred from the licensor to the licensee. And so this is something that you want to make, you want to ensure that you're being granted the right rights, not just, if you were expecting an exclusive license and it's not exclusive, or you were expecting this field of use and you have a different field of use. In fact, we did include there the link to the DOE licensing guide for if you're interested. Again, which will be helpful almost in any, even for a university, because it does explain what some of the BIDOL requirements are in a license. For instance, before licensing, the licensor must meet some fairness of opportunity requirements where they have widely publicized that technology to anyone before they can exclusively license to any one company or individual. Okay? Then there's an article typically on consideration in financial terms for the license, and again, I'll be going through these. What are the terms? What is it that you will owe the licensor, and when? Also very important. In there, they may also be some diligence terms in terms of that you may have committed to bringing that product to market in a certain time frame. And signatures and appendix. The appendix is usually a list of the patent portfolio and any other pertinent information that may be required. Let's see. Do I have that here? Yeah, I think I will talk about that in a minute. But within that, the license, you also have discussion of the patent prosecution, who will lead the patent prosecution, who is responsible for reimbursement, and when. Typically, once you license a technology, if you are the exclusive licensor, it will typically give you the right to work with that patent attorney on the patent prosecution and any actions that come up during the prosecution of the patent, as well as your responsibility for reimbursement. I can tell you that even though a lot of universities and labs will defer patent costs to date, a lot of them will expect you to take on any recurring or occurring reimbursement of those patent fees, for instance, the maintenance fees and so on. And then the condition of grants. In terms for federally funded research, you have some U.S. competitive clauses that are required. Again, going down the list here of standard terms, I've gone to the next slide. There's some insurance. They will typically require you to have some insurance, obviously in case you are sued, and then there's liability that you typically will release them of any liability, either the institution, the individual inventor of that technology. And then milestones. And along with milestones, there may be some milestone payments as well, and then product development. And then another important part of that license will be fees. What is the royalty? In case of a startup, you might provide equity in exchange for upfront fees for that. And there's a number of ways. I can tell you that most licensors will balance royalty to equity. So the higher the royalty, the lower the equity, or the more equity you provide, the lower the royalty fee. So you should be prepared to balance those out. And in terms of for DOE, I can tell you that we have some march-in rights. And again, that's actually across the board for BIDOL. And march-in rights is the right that the government will have to federally funded research to ensure that it's being deployed and that somebody is not just sitting on the technology to prevent it from taking them out of business. And so the government can, if the government can show, and again, this is really important, the government must show that there's a viable commercial market for this intellectual property that you're not capitalizing on, and then it can compel you to provide a license to somebody else or practice. Now, march-in rights has never been exercised. I think it's been threatened once since its existence, and clearly you can see why. In a capitalist society, what patent owner would sit on valuable IP, and not make money either through licensing or actually producing a product? Again, the one case would be if you're trying to block somebody else, or that technology might compete against something you have on the market, and in which case, I don't think you'd want the government coming after you for that. So, and then there's the U.S. manufacturing clause that says that we will provide, one, preference to somebody who offers to manufacture in the U.S. So all things being equal, the licensor of this federally funded research must provide preference to a company that offers to manufacture in the U.S. for the U.S. market. So I should also mention that. That's, we require U.S. for the U.S. market, because we get this question and practices and invention overseas, assuming that we do have IP protection overseas, because if we don't, then they're free to practice that invention. But if they don't, if we do have protection, they are able to manufacture overseas for that. And it also states that if you provide an exclusive license to somebody, that they also have to carry on this U.S. preference to their sub-licensees. So suppose I exclusively license from the Department of Energy, and then I want to sub-license in a different field to two companies, and one company is offering to manufacturing here in the U.S., then I must provide preference. So that preference carries through a license, okay? And as you may expect, we have some export control requirements as well for those items that might be export controlled, okay? Moving on here, so some of the terms I've already discussed, and these are the terms that are typically negotiable, and those are the upfront fees. And these upfront fees can take on many shapes, forms. Again, they could be just an upfront fee of a license. They could be broken up into different payments throughout the year, throughout the life of the license. But they will typically, and again, in the case of an exclusive license, you can expect to have some minimums. And again, this also helps in due diligence because, again, if you are required to pay a fee, you're going to move forward towards commercialization. You're not going to sit there on the intellectual property. So you have some minimums, and they could be yearly minimums. And along that, you'll have the royalty rate that you discussed, and the equity. And again, remember I said there's typically a balance between the equity and the royalty rate. And again, diligence and milestones, patent costs, and during the licensing negotiation, you will negotiate whether some of these patent costs will be deferred. And again, a lot of universities and labs are kind of jumping on board on this. At least I know I've encouraged DOE labs to defer patent costs for 1 to 2 years for newly created companies. And a lot of, like I said, this is something that has been pretty standard for many universities, where they defer patent costs for typically up to 2 years. Those are incurred costs, ongoing costs the licensee may be required to pay, because no institution wants to be responsible for maintaining a license for somebody. So if they decide they no longer want to pursue that patent, but it's licensed to a company, they will be compelled to keep it active, and they may not want to have that responsibility. So they often will shift the responsibility of ongoing patent costs to their licensee. And again, that's in the case of an exclusive license. And again, you could see it for partially exclusive licenses or even for non-exclusive licenses, because you may think, well, why do they need a minimum if it's non-exclusive? They can license to other people. But just having a non-exclusive license out there may hurt the licensing opportunities in the future. And then somebody who comes in later on says, well, I want an exclusive, and you have this non-exclusive just sitting out there. So I can tell you that even for non-exclusive, you may have a minimum. It may not be as high as for an exclusive, but so don't think that you're home free if it's a non-exclusive license. Fields of use, again, this is something that must be clearly defined and that you must be comfortable with. I know this is something that causes a lot of discussion in terms of, and I can tell you what I've seen being here at the Department of Energy, because we have an obligation to widely deploy the technology. A startup would typically want all fields of use, and the labs will want to have that individual or startup show how and why they need all the fields that they're requesting. And they want to make sure that you have plans to commercialize in those fields of use. And again, I know this is definitely one of the more important terms in that license, because again, one thing that we all know about smaller companies and startups is that you will change. So one of the things I've tried to support is that, providing startups a wider field of use, because, you all need that runway to take off. A lot of times you may think you're going to sell a product, and you do a 180, and it turns out you're going to provide a service. And you want to make sure you have enough IP flexibility to pursue all the fields that you feel are viable for your company to pursue. But again, not being over greedy and understanding that the labs and the university and the nonprofit does have an obligation to BIDOL of wide deployment. And again, I think we've discussed enough the exclusive and non-exclusive nature of the license. And again, it could be field limited, so I could do the field of automotive. It could be even within a medical field. You can have a subfield. I've done, for brain, just brain or the gastric intestinal tract. So it could be very field specific. Not, you may think medical. Oh, you could get down to even finer detail than just medical, or countries. I should also mention that it could be exclusive by countries. So lots of ways to slice up that term. Some additional terms that are quite important, and I think I've mentioned this, the patent reimbursement. I think I've spoken enough about that and the way it's typically done. Some other additional terms that you may not be thinking about are the right to sue for infringement. I know early on, at least in my tenure at Caltech, we had the right to sue. Typically, the licensor will have the right to sue, will have the first right. And in the license, it will usually say if the licensor refuses or is unwilling to sue for infringement, then that right is then transferred to the licensee. But typically, it is the assignee of that patent that has the right to enforce it. So if your license agreement is silent on that, you usually will not have that right. Another important right is the sub-licensing right. So if, depending on your field of use, and again, this is for the sub-licensing rights will only apply to exclusive licenses. You could decide to sub-license to others, either within the same field of use that you have, but you cannot sub-license anything greater than what you already have, which is really important. So if you only have the automotive market, that is what you can sub-license in, or within that subfield. You can't obviously go out and license in the aeronautics market. So that's typically the right, and the sub-licensing, and with sub-licensing, there are fees. So, and it will be different than your royalty fee, and it's typically a higher percentage because depending on the technology, it could be just a flow-through license where you have done no additional work on that intellectual property, but you are just sub-licensing it. And so the licensor will expect a higher fee for that, and again, it could be anywhere from 15 to 30%, but higher. That's just, what I've seen, that the sub-licensing right will be a lot greater, especially in the case where, again, it's just a pass-through license and you've done no additional work on that intellectual property. Okay. Again, just getting some specific based on the participants that I had gotten from Adam, of the folks that typically attend the ARPA-E University. I'm assuming, again, that most of you are individual inventors, individual small companies, and so I wanted to focus a little bit on the needs, special needs of startups. And again, as I talked about, that in exchange for upfront cash, a lot of startups are willing to provide some small equity share to the licensee, and this has been pretty standard at universities. And there are now even companies, I know at least one, Osage Partners, that will buy the rights from a university to make sure that their shares are undiluted. So, or to have the option to continue to buy into further financing rounds for that equity. So it's definitely something that is increasing in popularity for universities to retain. I know a lot of labs for the government-owned, contractor-operated labs have the ability to retain equity. The government-owned, government-operated labs do not. And so it's unfortunate because you probably do not have that negotiating tool when dealing with strictly government-owned, government-operated laboratories. And so in exchange, most universities and labs that are licensing to startups need to view these startups as a partner. And so, again, they will defer patent cost reimbursement that I spoke about. They also will defer that minimum royalty payment for a few years, and that's definitely something that you want to make sure that you've discussed. You don't want to put yourself where you are paying annual minimums before you have a product on the market. But at the same time, the university has to weigh your timeline with their need to ensure that commercialization is taking place. So, you do have a say in that, and you should be realistic. And I know a lot of times, as you all know, time flies by, and you think, I'll have a product out in 18 months, and that 18 months turns into, 36 months or longer. And so you want to have some flexibility in there. But I can tell you that, again, for an exclusive license, you will have some minimum royalty payment, and that is usually linked to net sales. Reduced royalty rates. You may have some milestones where, after a certain sale target, your royalty rate can be decreased. You could have a stepped royalty rate, so up to this number, your royalty rate may be 4%. Above that, then it goes down to 2%, and anything above, $1 million in sales or $1 billion in sales, whatever your market may be, your royalty rate will decrease. So that's something that's very important to note, that you don't necessarily have a flat-out royalty rate. It could be stepped. And again, the exclusivity. And again, here I mentioned exclusivity just because it is something that is usually of higher importance to small companies and startups. That is typically your cash there. That exclusivity. That is the value of your company. The right to be able to keep competitors out of your field. And then just to give you a feel for typical distribution that these startups will have, most universities are not trying to be the owner of your company, and nor should they be, or labs. The majority share of the company does belong to the founders and those that are working on the company and making it successful. And then clearly where you have an option pool for new employees or new investors and so on. So, want to help startups here in this way. And, again, the licensor should not be trying to get so much equity where, they're breaking the company's back financially. And so they definitely want to make sure that you have enough time and room to grow. And, again, just in terms of the minimum royalty payments, they're typically not due 2 or 3 years out. And then again, are willing to take a lower royalty rate in terms of higher equity. So, and sometimes the licensor will insist on milestone payments, and a lot of people do that. To me, it's counterintuitive in terms of if you're doing really well, or you have these milestone payments, but it does happen. And in those cases, they may want to reconsider the motivation there for that. Okay, so that ends sort of the general overview of terms, and again, I'd be happy to answer any questions at the end of the presentation. But I was also asked to provide an overview of what you could expect from your tech transfer offices for those, professors or students or individuals that are working with the university. Increasingly, the tech transfer offices are actually being viewed as a recruiting tool for attracting and retaining talented faculty. So it's definitely a service that the university is seeing as providing, because in general, tech transfer offices unfortunately do operate in the red, and a lot are just basically trying to stay afloat in terms of recouping their costs. But I just wanted to provide you a list of the typical activities that a tech transfer office will do. And again, this is giving credit to Autumn, which is the Association of University Technology Managers. And again, the most basic function that a tech transfer office does is that they will identify and protect new inventions. Now, they only know about new inventions when those are reported by their faculty and staff, and there's a technical evaluation that occurs. There's some level of outreach out to their scientists in terms of what the patent process is, what is the licensing, what could you expect as an inventor from the process. And this is very important because if the inventor is not feeling engaged and that they're part of the process, they're less likely to report. Also, the process is onerous, so you don't want a 20-page document for reporting inventions. And, I've seen some places that do a great job in a quick initial five questions. I know some universities will just have the professor submit their paper as part of the disclosure. They definitely want to make it as painless as possible for reporting, especially when a lot of scientists, at least I know on the federal level, are under full cost accounting. So anytime that they spend outside of their direct charge is not time that they're reimbursed for. And so you want to be careful, cognizant of that. The tech transfer office always has the compliance responsibility, so they have to comply with the federal regulation that I mentioned, one, in reporting what those inventions are. They typically also have to report when those inventions are licensed. And in the case of U.S. manufacturing, sometimes they're asked to provide proof of that. Or if there's a waiver that's requested, I don't think I mentioned that. So in all cases where there's a U.S. manufacturing preference or requirement, there's also a waiver process in place, or there should be, where if a company can show net benefit back to the U.S. economy, whether or not they're manufacturing here in the U.S., they are typically provided a waiver to show that. Okay, an example of that people always use, again, not that this applies to Apple, but in the case of Apple, where you have a lot of manufacturing overseas, the number of service jobs that are created here in the U.S. just for service and sales, you may say that, that cost is outweighed, or there is significant benefit back to the U.S. economy. Royalties, collection, and distribution. The tech transfer office is also responsible for the collection of these royalties and the distribution of those royalties. And I can tell you in most cases, and the patents are equally owned by all inventors, and I know this is something that would be touchy because unlike publication where, you have the main inventor, the lead author is the first author on a paper. On a patent, everyone is equal owner of that patent. And when a patent is licensed, most universities, most licensors will distribute those royalties equally among all the inventors. I had one case where all the inventors got together and decided that they would have a different distribution, and I know that was allowed only because everybody signed off on that, but typically, royalties are shared equally among all inventors. And they also provide support in managing conflict of interest. Most institutions have a process in place for if the inventor wants to license the technology or the inventor wants to be part of a company. They have certain requirements, certain processes that you must complete in order to ensure that there's no conflict of interest. They also help manage interinstitutional agreements, which I can tell you are a lot of fun. But as you know, scientists will collaborate, and they often collaborate with somebody outside of their home institution. And so they will manage those. So you may have a joint invention between two universities, a university and a corporation, which again is often the case for state-sponsored research, or a scientist at a university and somebody at a nonprofit or another research institution. And so they typically handle those. They will also have boilerplate agreements or template agreements for non-disclosure agreements, for material transfers, for the options that we talked about for license, and even for memorandum of understanding. And sometimes the sponsor research function is co-located with the tech transfer office, and sometimes it's not, just depending on the institution. And then they are also responsible for the development, commercialization strategies for those technologies. A lot of institutions will have an external panel that comes in and looks at the technology. It's also important to know, and this is something that I always stress with scientists, explaining to them that the reason why their technology is not being patented is not based on the merit of the technology, but it's purely a business decision. Often is, will this technology be commercialized, and will we be able to recover patent costs? Patents are very expensive, anywhere from $10,000 to $100,000, depending on the technology, depending on the countries that you expect to pursue patent protection for. So they're very expensive, and you want to make sure that at a minimum you're going to recover patent costs. One of the last figures I saw was that less than 1%, that's 1% of all patents actually generate income. So that's a pretty statistic, and so you want to make sure that when you're spending that much money, there's at least you have an opportunity to recover those costs. So just overcoming some barriers, I should mention that not all universities, institutions have a tech transfer function. A lot of times it is just an additional duty of their general counsel or of another office within the university of the institution that does licensing. And in that case, it might be a little more difficult, or it may be easier because they just have a click-through type license. But there are a lot of resources that you can turn to, and this is not by any means a complete list of those. This was actually, unfortunately, done really quickly, and I would have included more, but I know, for instance, ARPA-E has a number of regional resources that you should be able to turn to. Also, the satellite tech transfer USPTO offices that I alluded to at the beginning of my talk will provide some support. There's a number of regional innovation hubs, some of which are funded by DOE. Excuse me. Around the country. There's also, again, Autumn websites and a number of Kauffman Foundation that have resources for individual inventors and startup companies. I'm losing my voice. I think we're almost at the end here, so we're good. Some lessons learned. Again, not sure. We may have actually some tech transfer professionals on the line, and hopefully they'll agree with some of these. But any licensing is going to start at the intellectual property stage, and it's going to start with some inventor who develops some really neat technology. And so, it's really important for these tech transfer offices to have good working relationship with their scientists. It's also going to enable you as a licensee to have access to the inventor, because anyone that has a patent or has licensed a patent knows that a patent is not very useful without that background knowledge and know-how, and that's typically resident in the scientist or the faculty member. So as you negotiate your license, you should also be able to negotiate what know-how will come along with that license, including some discussion with their inventor and their scientists. And typically these scientists are the best marketing tools. They're the ones that are publishing papers. They're going out making presentations that companies are listening to and trying to find out how that technology can be applied to their product offerings. And then I would also just encourage you all to get some basic knowledge of the patenting process. What the different bars are, what constitutes a public disclosure. In the past, somebody may think, oh, well, I just emailed my paper, my presentation to this one individual. But you don't know if that individual, one, is posting your presentation or your information to their company website, or forwarding it to, 500 technical staff of their organization. So you should always assume, again, and this is back to you as a scientist or as an inventor, if you go out and publicly disclose your technology, especially with this new American Invents Act and the fact that the way the legal language around the grace period is causing a lot of concerns for people, and assuming almost that this grace period, again, being better safe than sorry, in that you want to make sure that you protect the intellectual property before you go out and make up a disclosure. And again, what constitutes a public disclosure? Again, I would err on the side of caution there. Anytime that you're sending out a publication or you're speaking with someone and not knowing, where that document is going. Also, it's very important that you never offer your intellectual property for sale before you have filed for patent protection as well, because that will constitute a bar against you in obtaining a patent. And understanding the restrictions. Another important topic here, that's the last bullet, which is understanding the restriction regarding the use of licensor's name in presentation. You will see most institutions will have a clause, an article within the license that says that you shall not use their name to construe or implicitly imply a support of that product. And but most cases you can state the fact, which is I have licensed X. This technology has been licensed from this institution. You are always able to state the fact. Okay, you can't go around, like the one time that the most flagrant act of this I saw, there was a company who went out and said, do you think Caltech would license this technology to just anyone? And it's like, and that may constitute or represent some kind of endorsement, and that's, you can't do that. But, and I say this because, I have seen this come up more than once, where a company will present something and the licensor will get upset. Either way, one, that you're not giving a proper attribution to the scientist or the technology, or secondly, that you are crossing over that line of either explicitly or implicitly referring to some endorsement. So that's just something, like I said, that I've learned, over the years to be very careful of, and that you make sure that you are on the same page with the licensor in terms of how you can use their name. For instance, through many years at JPL, people assume that if you license something at JPL, you could use the NASA meatball, which would not be the case, because, Caltech didn't even have the right to that was held at NASA headquarters. So just as an example. And unfortunately, I can see that I've gone over time here, and we're not going to have a lot of time for questions, but hopefully we'll have a few. So I think I will end right here.
Great. Thank you very much, Karina. And I think that we do have some good questions coming in, but I think you've given a good overview. And any topic like this is just a starting point. We can't, Karina today can unfortunately consult with each of you on your idiosyncratic situations, but I think this should post, just so everyone will know, the slides from today's presentation will be posted on the ARPA-E website within a week, as will the other resources Karina mentioned, such as the DOE licensing guide, ARPA-E's technology resource map, and other sources that can help you out if you don't get your question answered today. I want to start off with a couple questions that focus on the relationship between universities and startups. And so we'll go to one that says, if one inventor is from a university, the other is from the startup, does the startup still have to license technology from the university?
Yes, they do. All universities, most universities and nonprofits, and just as companies do, when you are an employer there, and actually with universities different actually, because undergrads who pay to attend the university do not typically have to assign to the university, but as a grad student, especially if you're on a fellowship or that is a federally funded research that's being conducted, you are obligated through your employee or student assignment to assign to that university. And And so you assign to the university, and at times, as I mentioned earlier, if the university decides they do not want to file for patent protection for your technology, and they assign to you, in that case, you don't have to license. But in most cases, if you've expressed interest in starting a company, most universities will want to retain title, and so you will want to license from that university.
Great, and that answer might already start to answer this question, which is, if it's a private business owned by students, it's used some university resources, and they're giving the example of a machine shop, but they use all their own materials owned by that business. Does the university then have rights that the patent?
So it depends what kind of agreement you have in place. If you are just paying for the use of equipment, and it's very clear that it is your own resources, it's your own staff, you typically would not, the university would not owe that technology. But again, it's very different, and depending, what resources you're using. But I would tell you to make sure that, if you're just going in and using equipment, the university should not be taking claim for that technology. And if they are, then you just need to find another partner to work with.
Okay. Taking a broader step back, we have a question here: how easy is it to amend a license? We've talked about a lot of different terms, and I think you mentioned a good point. If you're a startup, you might be pivoting a lot. And so, is this a working document, and how does that typically play out?
So it depends on the terms. It should be. It is definitely a living, breathing document, and depending on the tech transfer office and their resources, it can change. Obviously, you can't think you're going to go back in there and renegotiate all the terms, and there's usually some give and take. So if you want to come back in and maybe pay less royalties, then maybe they'll want more equity. Or if you want to push out the payment a couple more years, then I may want to increase that payment when it is due. So it just depends on the terms of that agreement. For instance, if you want to increase the field of use, then I may again want to increase the royalties or some other payment. So it just depends on the term. It is definitely negotiable, and you should be ready to go back and negotiate any terms that you need to make your business successful.
And then maybe another similar big picture question, just going back to the issue of patent costs. I know you mentioned that oftentimes licensors will defer those costs, particularly to startups. Can we just, for brass tax purposes, define a few of those typical costs? I assume they're royalties and different shapes. You did talk about them. But also how the typical terms, I guess, for startups when they're negotiating. The question is, who might pay, for example, prosecution costs? Like thinking through what are the different types of costs that might be deferred if you were a startup receiving a license.
Sure. So typically, the costs that are typically deferred are costs to date. So basically, I like to call those sunk costs. So anything that the university has paid or the licensor has paid up to that point, they will or can defer, or at least partially defer or defer part of that, okay? And some licensors will go as far as continuing to defer those costs. And then, so it just depends where you are in licensing. So if the patent's already been issued, maybe you're lucky and all those patent costs are deferred for 2 years, and then that licensor will expect you to pay ongoing fees, which just may be the maintenance fees for that patent. If when you come in, it's only the provisional, and then there's some prosecution fees, which are much higher, that are due later on. The licensor may require you to pay all of those fees or part of those fees, because they definitely want to feel like you have skin in the game. So they definitely want to make sure that you are as invested in that patent as they are. They don't want to be left holding the bag where, you could just terminate that license at any time and then, I'm stuck with all the fees.
Right.
So it just depends how much. It's usually the fees that have been paid to date will be deferred, and ongoing fees, you're usually on the hook to pay some of those.
Maybe digging into royalties in particular, the question here is what are the range of royalty rates that you've experienced? Would you say there's an upward or downward trend? They tend to be sales or revenue or profit-based?
They typically are on sales, net sales, and I've been limited. Most of my experience has been with one university in terms of royalty rate. And I can tell you typical royalty, and again, it varies depending on the field and the market, but I would say somewhere between 2 and 6%. And I know for like medical devices, often it's a lot lower than that, or biotech technologies, but most of the royalties rates I've seen are somewhere in the range between like 2 and 6, and mostly between 2 and 4, to be honest.
Okay. Quick follow-up to that, someone's asking, can you define net sales? And I'm just saying that can maybe be defined very differently depending on the industry.
Sure. So let's see. Net sales typically refers to you're removing operating costs for that and any cost associated with getting that product out to the market. And I was trying to see here if we had a good term in our boilerplate here, but it's not because we don't. This is just for a non-exclusive license. But and again, I shouldn't even really talk about this because it will be different. But those net sales usually take away, like I said, the cost of the product to produce.
Okay. And maybe one final question as we are just at 2 o'clock. Going back to the American Invents Act, obviously that has had a big impact, and you provided some advice today on thinking about provisional patents, really getting out there in front of that. The question here is, given the novelty rules encouraging early disclosure, how do you see AIA impacting someone's publication strategy? And whether or not and I think they might be referring to, if you can get something published without a patent, right, that might be a way of protecting a patent by making it publicly known.
Sure, yeah, so it depends what your strategy is. So if your strategy is to make something publicly available so that nobody else can retain a patent and block you from using that technology and, publish to your heart's content, so long as, again, you've met your employer's obligation, if you have an obligation to report, that might not just be in your hands. And so you'd want to consult with the office that may own that invention. That's one thing, but if your strategy is to protect that technology and have some patent at a later date, you definitely want to file at a minimum a provisional patent to get that date. And especially right now because these new rules are just being implemented and folks are a little nervous in terms of, again, what does the legal language really mean. And so until we have some cases that have been tested, I think, again, I would err on the side of caution.
Fabulous. Karina, thank you very much for your time today.
Thank
we appreciate you having. And thank you to everyone for dialing in. I know that we weren't able to get to all of your questions, but we appreciate your interest in ARPA-E University. Please, when you receive the email later today with a link to where you'll be able to find a recording of today's presentation and the slides, the opportunity to provide some feedback just by hitting reply to that email. If you do have feedback on today's presentation, suggestions for future topics that you'd like us to cover here at ARPA-E University, please let us know. And again, appreciate your interest. Thank you for joining us today. Goodbye.